Hi, I'm Louisa Sijabat, a liquidator and bankruptcy trustee. Today's question is, what is a Part 10 personal insolvency agreement and should I do one? So a Part 10, which is sometimes written as a Part X because X is the Roman numeral for 10, personal insolvency agreement, is a legally binding agreement between an individual and their creditors, that is, the parties they owe money to. Now, how does this work? So, somebody who has a lot of debt personally as an individual might see if they can explore an option with their creditors as to whether their creditors might be open to accepting some sort of compromise. That is, instead of the payment of their debt in full now, would they accept some sort of compromise in payment? Now, sometimes the compromise is in amount, sometimes the compromise is in payment terms, or some combination of both or various other potential compromises that can exist as well. So for example, in exchange for a person who might have 20 creditors owing $1 million, the individual might put forward or have somebody put forward a proposal for them that says that we propose that these creditors be paid, for example, 30 cents in the dollar in equal installments over 12 months. So obviously that's not the original payment terms, but the proposal might be a better alternative for the creditors than that person declaring bankruptcy. Now, a Part 10 personal insolvency agreement is quite complex, and because of that, it can be quite expensive to even just put a proposal to creditors. So typically what I will say to people is you do have to have access to a reasonable source of funds that wouldn't otherwise be available in your bankruptcy. Let me explain. For example, if a person had a piece of real estate that had equity in it, that would be available to the person's creditors in that person's bankruptcy. Now, if, for example, they had a third party, whether that's a family member, friend, a superannuation fund, or anything that wouldn't ordinarily be part of a bankruptcy. And if those funds will be put up to pay these persons' creditors, then that might be a situation in which a personal insolvency agreement or a Part 10 agreement could begin to look viable. In addition, there should also be a reasonably significant amount of money put forward to creditors under this sort of proposal. There's no rule that says what the minimum amount is, but because it costs a fair bit in professional fees to even give this a go, usually the total sum needs to make the whole experience worthwhile. As a ballpark guide, what I tend to tell people considering a personal insolvency agreement proposal is it usually costs starting from about $20,000 to try to just put forward the proposal to creditors. And then on top of that, there would need to be some proposed payment to creditors. So as you can see, this begins to add up, which means it tends to work better for higher debt amounts or people with access to larger amounts of cash, where that might solve their situation with their creditors, if it is acceptable to the creditors, and keep this person out of bankruptcy. It is quite complex, but if you're beginning to think this could be something for you, reach out and we can, of course, talk in more detail.